Here sworn in as his.
You swear at me.
No,
Been trimmed so far.
part of his duties. Is he
We
already?
have to. We can just throw rocks at him.
Yeah.
I think by being sworn in as the position,
Yeah.
it covers it.
The position being sworn in.
And this is
Is this tempting though? Yes. This is. Yes.
Ann.
Okay, that's what I was getting at. Is the position
Austin,
count?
nice to meet you.
Yeah, it's the man. Welcome.
Thank you very
So he
much.
doesn't have to swear in this because he's been
All
sworn in.
right. Okay, the Municipal Planning Commission for October the 26th special meeting will now come to order. Mrs. Blankenhorn, will you call the roll, please?
Mayor Starr,
Here.
Mr. Sawyers,
Here.
Mrs. Ellsworth,
Here.
Mr. Hawkins,
Here.
Mr. Swallow,
Here.
Mr. Deal, Mr. West. We have a quorum.
We have a quorum. We are in session. Just also to note that I want to thank Mr. Ball for substituting in as the acting Safety Service Director during the short time when we were looking to find a replacement for Rick. And we'd like to welcome Mr. Salyers on the commission. Also, Mr. Braun for substituting in as this acting Safety Service Director on those other duties that were not engineering related. So thank you both for your help. And also Mrs. Blankenhorn for her substituting in on some of those duties as well. So thank you all three for helping us out. And welcome, Tanner. We're all very happy that you're here now. So anyway, okay, we have meeting minutes from October the 12th, 2023. Are there any corrections or additions to that?
Mr. Mayor, in lieu of your previous statement, could we make a note on the movement of the motion that Mr. Ball was acting as acting city service safety director rather than city engineer? It's
As a Scribner's,
note.
as a Scribner's note?
Yeah.
I think we can do that, certainly.
Yep.
That's fine.
I think for the future,
Sure.
it's better to be clear.
Very good. Very good catch.
The minutes don't show where it was sitting.
Right,
Right, right.
exactly.
The
Okay,
video might.
any other corrections? If not, is there a motion to approve the minutes with the Scribner's error corrected?
So moved.
Second.
Been moved and seconded. Any discussion? All those in favor say aye.
Aye.
Opposed, nay. They are approved. Okay, we have two items for this afternoon. First one is Colonial Woods condominiums, and Mrs. Blankenhorn, I'll have you review that, and then we will get started with participation from those who are here to talk about this.
2023 MPC 03 Colonial Woods Condominiums parcel number 71-00001.022, a change to the comprehensive development plan.
Thank you. Do we have someone here to speak on behalf of this project, present this behalf? Would you, sir, come to the, before we get, I'm sorry, I forgot to go over the ground rules for this. We'll get to you in a second, Mr. Lowe. Sorry about that. I forgot to read this. As a reminder to all of us who are here today, the purpose of the Municipal Planning Commission is to balance the public good with the private property rights and interests. Also, the Commission carries out all other powers and duties conferred upon it by the City of Mount Vernon's zoning ordinance or other city ordinances and the laws of the state of Ohio. This is a public meeting and there are rules of decorum that we follow. We are committed to the democratic process, individual rights of expression, robust debate, and tolerance for different viewpoints. The following general rules of civility are expected, including addressing others in a respectful manner, no insulting, personal attacks, intimidating, or offensive communications, no harassment, no willful destruction or damage of property, and no disruptive behavior. Please silence all cell phones and other electronic devices and refrain from private conversations during the meeting. If you need to come and go throughout the meeting, please do so in the least disruptive manner possible. If you are offering public comment today, you must first be sworn in by reading the statement at the lectern, and you can keep your comments to 4 minutes, except for those who are actually making presentations on the case there. Again, the purpose of this commission is to oversee that the law is followed and planning concurs within which the spirit of those laws and regulations have been adopted by the City of Mount Vernon and the state of Ohio. Mr. Lowe, you want to come on? Sorry about that.
My name is Doug Lowe. My professional address is 23 East Church Street, Newark, Ohio. I affirm that my testimony is truthful to the best of my knowledge and ability, so help me God, or under penalty of perjury.
Welcome.
Thank
Floor is
you.
yours.
Got my little. We're here about the village of Colonial Woods, but that's really a misnomer because we're doing some developing property behind Colonial Woods. And at their request, they didn't want to have us have a similar name, so there would be no confusion. So our plan is to call it Gilcrest Meadows so that there won't be any confusion between us and them, which is, again, something they requested. They want to make sure the people weren't confused about where they were coming. If you will show the next slide, please. This was the original plan that was developed for the site. It was a plan that had the build out, and a lot of this has been built out already. A lot of that is what is Colonial Woods, kind of the lower portion on the right-hand side of the screen. That's all there. We want to build a few more buildings, but not to the totality of what's on the original plan. If you would look at the next slide, we're just going to build a portion, these additional buildings. The rest of the land has been sold off. I think it's important to remember that these buildings are in the exact same place as the prior buildings on the plan. Nothing has changed. The access to them is the same. The specifications for the buildings are the same. And there's really no difference from the plan except it's not as big. And we submit that's a minor modification, if you'd show the next screen. Minor modifications don't need to be submitted to council. And that's under the statute. Such modifications shall not increase the overall density of the site or change the essential character of the approved plan. We're not increasing the density of the site. If anything, it's less because we're building far less buildings. But again, on the same amount of land we were building before for these particular buildings. It doesn't change the character of the approved plan. The buildings are the same as what they were going to be. They're going to look the same as what they were going to be before when this was all approved. And I would note that in their resolution for this adopting this plan, it says, doesn't say how many buildings we have to be pulled in. It just says the general plan is attached. And we are in line with that general plan. It's just smaller. I would also say that if this were reversed in order, if we had built to the point we want to build to and stopped and then sold off the property, there wouldn't even be an issue. No one would be saying, wait a minute, you got to finish and build out the rest. If you would flip to the next screen, please. Now, Fairborn, Ohio has a similar statute, and I know you're not bound by them, but it's the same kind of language. And it was important to me because there was a court case interpreting that language. I couldn't find any interpreting yours. But it says minor changes altering the number, size, or use of land and buildings, or substantive changes may be authorized by the planning board if it deems them consistent with the purpose and general character of the approved plan. Now here, we say this is perfectly consistent with the approved plan. Again, I won't want to beat this to death, but the buildings are in the same place, they're the same size, they're the same specifications, they have the same roadways, and nothing much else needs to be done other than construct those buildings. The infrastructure is basically there. The utilities are there. Be hooked into. It doesn't need to be expanded. We're not going to be running anything through the middle of Colonial Woods. It's not already there. Those lines have already been run for the city. The storm pond, which is there, is large enough. It was built large enough originally. That will not have to be expanded. And if you do the next slide, I know that flip the next one. I got ahead of myself. I know this group was very concerned about how we were affecting Colonial Woods. And so, since the time of our meeting months ago and now, Mr. Horvath met with the trustees or negotiated back and forth several times on a very comprehensive cost-sharing arrangement. Once they came to the terms that they agreed upon, then it went to the attorneys. I drafted something. Their attorney looked it over, made some changes. We went back and forth. And we now have a recorded plan that covers everything anybody could think of. Maintenance of the roadways, because there's going to be joint use of the roadways, snow removal, the lighting on the roadways, how that cost is going to be split, who's going to maintain the pond, and how that is going to be split, the cost of maintaining the stormwater pond. The sign, how the sign can be altered to add Gilcrest Meadows onto the sign at the road so people know where they're going to, and how that cost is going to be split. And basically, when it comes to that, we're making the change on the sign, so all those costs would be ours. But there's a formula, there's a very comprehensive formula that was put in place that the cost to Gilcrest Meadows will gradually increase as they add more buildings because
Pardon me, Mr. Lowe. Can I ask a question?
Sure,
Did you swear yourself in?
I did.
Okay.
Yeah.
Okay, that's fine. I just wanted to make sure I was a little.
And it covered everything that between Mr. Horvath, Colonial Woods, and the attorneys could possibly think of that would come up. It talked about how we're going to attach the utilities, everything we could think of. And for most of this, Colonial Woods is in control of when things are going to be done on the joint areas. And basically, then it'll come to Gilcrest Meadows to have to pay for their share of that. But they're going to control who does the snow removal and all those types of things, because we'll be using part of it, they'll be using all of it. So it made sense, even down to the things about who's going to cut the grass around the pond. That's in there. And I know they sent this group an email, because they copied us on it, that said, I just want to let you know that Colonial Woods residents have received a notice regarding a meeting on Tuesday, October 26th for the development plan. Unfortunately, I'll be out of the state and cannot attend. However, Linda K. Rex and Dean Donaldson will be there, and I assume they're here tonight. And just for the record, we signed a cost-sharing agreement, which I brought to your office, and Brian Ball copied you on. After that, I recorded it with the Knox County Recorders and sent a copy to the developer, which was us. They did the recording, and I've got that with us if anybody wants to look at it. And the developers also addressed all our other concerns about things that weren't quite done in the Colonial Woods development at this time. So hopefully we've satisfied them and the concerns of council, or this group. If you would show the next slide. Well, I covered all that. I'm getting ahead of myself again. This shows where the utilities have already been run. Those are existing. We just have to tap into them. We did make somewhat of a change in that the engineer, or the water department, wanted us to tap into a different water line than the one we had originally planned, and we've agreed to that. It'll make it easier because it'll be easier to meter the separate water to the two communities. If you go to the next slide. Again, this is what it was going to look like on the plan, and now here at the next slide shows you what it is going to look like. We're just taking sections out, and the yellow sections are all it's going to be developed. The solid orange has been sold off, and we don't plan to build those little pieces on the end in the orange boxes. So we're just downsizing this. It's not going to be as big a community, I believe, and I hope they'll tell you the same. I think we all agree that we've addressed their concerns as comprehensively as we can. I'm not going to guarantee you that nothing will ever come up. I've never written any agreement yet that 20 years from now, something that no one thought of comes up. But it was our intent, even to the way that the new homeowners association, which is going to be separate from theirs entirely, is going to be funded a little more in advance than they normally are to make sure that the money is there for Gilcrest Meadows to do its part of this. So if anyone has any questions, I'd be happy to address them.
Any questions for Mr. Lowe? We may have you back up. Go ahead, Mr. Byrne.
So this is going to be a separate condominium, is that correct?
Yes.
And have you provided us the documents for the creation of the condominium?
We have not done the declarations. We have them, but we haven't filed them yet because we can't file them until we have something to declare. Mm-hmm. And until we know from this group that we're allowed to do this and then actually have a structure, because as you know, we file the declaration when there's a structure to declare. But we have those with us. They're fairly standard declarations that you see in most condominiums. But we haven't filed anything yet because, again, it'd be premature.
And in the case that you cited, was the minor modification, was that creation of a new legal entity for the changes?
No, I think it's been a while since I read that case, honestly. I think it was just a change in the size like we're doing.
Well, you're doing other things beyond changing the size. You're creating a new legal entity for this.
Well, that's, again, if you go back to the resolution, it just says it'll be developed. It doesn't say it'll be developed under one entity. So I don't know that we were ever prohibited from doing that.
Well,
I'm not-
actually, you signed an agreement with the city. You were originally going to do it in 2 phases.
Right.
Phase 1 and Phase 2. And you sold off all of Phase 2, and there were a number of binding agreements that you said you were going to do if you created Phase 2.
That's correct.
Which
But we didn't create
Well,
phase
that
two.
was what I'm saying. So that's a significant change as well, that you're not doing Phase 2, correct?
Phase 2 was never planned and permitted. This plan is Phase 1, even the bigger plan. We had never gotten to the point. It was just, if we do Phase 2, we would need to do additional things, because if we added additional units, I think one of the things, and again, I haven't read that for a while, but if we added additional units, we were going to have to put in a turn lane, as I recall.
Yeah.
We were going to do some sidewalks out there, but that isn't happening. If anything, the need for those things will be less, us doing this, than if we just did all of Phase 1, because this is smaller.
Also, if we would have done phase 2, we would have had to create a new entity anyways, because the state statute requires you 14 years.
Yeah, well, that's true. So we'd had another entity, but we'd had to come and,
Another entity anyways.
so,
Mr. Lowe, you're representing Colonial Woods as,
no, I'm representing EJ Mount Vernon Partners, the developer.
so that there's a different owner for what you're suggesting?
Well, this was all a great big piece at one point. And then part was used to, part of that came out of that big piece to create Colonial Woods.
Right.
And then part of that big piece was sold off. This is the piece that is left of that big piece that we want to develop upon.
But Gilchrist Meadows, so how is Gilchrist Meadows different than Colonial Woods?
Gilchrist Meadows is going to be a separate homeowners association. Once the thing is built and we're established, we will set up a separate homeowners association with its own separate funding rules. Again, we're funding a little heavier up front than you normally have to in these, so there'll be money there to pay their share to make Colonial Woods happy. And one of the parts of the agreement is that the associations will share their year-end financials with one another to show that we're funding this to keep up with each other's end. So if there's an issue, it can be dealt with then. But they wanted, not only do we need a separate legal entity, they wanted a completely separate name. Colonial Woods did, so there'd be no confusion. So we thought Gilchrist Meadows was such that it wouldn't create any confusion about who owned what, or who you were coming to, if you were coming to visit, or the outside at large.
Will the sharing, will everything that's in Colonial Woods be shared by the owners of Gilchrist Meadows?
No, we won't. We're not sharing their clubhouse, for instance. We're sharing. What we share is the roadway coming back, because that's how we access it. We're sharing the storm pond. We each have our own storm drains going into the pond, but we're sharing the pond. The pond has to be maintained. We're sharing that. We're sharing the cost of the lighting on the road coming back, because that'll benefit both of entities. We're sharing the snow removal, because both of them need snow off the road that they're both using. We're going to share the sign, though the change in the sign is 100% on Colonial, or on Gilchrist part, because that's only fair, obviously. And they've got some approval rights on the sign. We can't just stick anything out there we want. But anything that we're both using, there's going to be a shared cost on. But then the things like, their water lines that serve their offshoots, that's their problem. Our water lines that serve our offshoots, that's our problem. The storm drains themselves on the different property, that'll be each entity's responsibility to maintain. It's just where we overlap, which is frankly mainly the road. There is some hook into some utilities, and the lighting on the road and the signage, and that includes everything. I mean, they came up with a formula that everybody was comfortable with about the percentage of the cost on when they pave the neighborhood, because presumably, when they go to pave the one road, they'll pave everything. That's normally how it's done, and it's cheaper that way. We have responsibility if during our development, if we do something unusual, wear and tear, damage the road or something, that's 100% on Gilchrist Meadows or the developer, because Gilchrist Meadows probably won't even exist yet during that phase, in the sense of they won't be up and running with a bunch of members, because the units will just be being built. But anywhere we could think of there was any low overlap, we have different formulas for different things because of the way they overlap, but how the cost is going to be split. And again, they wanted, and I understood that, and we understood it, and they're the ones who will say, it's time to pave the road. Here's who we're going to hire. Now, they'll consult with us, but ultimately they're going to take the lead on those things, because that made them more comfortable, and that was fine with us. So,
Any other questions for Mr. Lowe? Okay, Mr. Lowe, thank you very much. We may have you back
Thank you.
to respond to anything else. Anybody else wish to speak on behalf of this project? In support of this project?
Actually, yes.
Okay, please come up. We'll have you read the swearing-in statement, and then the floor will be yours.
My name is Linda K. Rex. My address is 108 Colonial Woods Drive, Mount Vernon, Ohio. I testify that my testimony is truthful to the best of my knowledge and ability, so help me God, or under penalty of perjury. I'm the president of the Colonial Woods Condo Owners Association, and Mr. Horvath worked very diligently with us to come up with a plan that we all felt was reasonable and good. So as far as our association is concerned right now, we believe that any of our initial concerns haven't been addressed. They will not have any usage of our clubhouse or our pool. And as far as the shared roadways and the shared retention pond, we think we've hammered all that out, as well as devising a system to charge back to the developer and or Gilchrist Meadows whatever costs that have been incurred on their behalf by us. We have, in the beginning of December, we're going to have them as part of share our budget with them, so they can see exactly what responsibilities they might have coming up. So we're planning everything ahead of time. We've even got that hopefully ready to go for you for this December, should this project continue. But we know we have no dog in the fight as far as the actual building back there, but we just wanted you to be assured that both parties have done their due diligence to get things settled and an arrangement made.
Thank you. Any questions for Ms. Rex? Thank you. Anybody else wish to speak in support of this particular project? Anyone wish to speak against this particular project? Anyone in general?
I would just add,
Would you come back to so we can get you on record there, please?
if for some reason you want to review these, I do have the drafts of the condo declaration and things that we plan to file once we start, but
Is there a time frame that we're supposed to have to look at those?
It's typically done with the comprehensive development plan.
Okay, thank you.
so,
Okay.
again, we haven't done anything further than this because we didn't know if we were going to be allowed to go forward as we want to.
Okay. Okay, thank you. Any other comment from the public? Okay. Mrs. Blankenhorn, did you receive any communications received either through the phone calls or in writing?
I did not receive anything in addition to the email that Mr. Lowe read during his testimony. I do have a staff report.
Would you share the staff report, please?
October 24th, 2023, staff report concerning 2023 MPC 03, Upper Gilchrist Road, the Village at Colonial Woods Comprehensive Development Plan changes. A zoning permit was applied for on September 28th, 2022 by Stoneworks Partners LLC to construct a 4-unit condominium on parcel number 71-00001.022. The application was denied by Development Services Manager Lacey Blankenhorn, citing Code Section 1163.03. A comprehensive development plan is required. The review note further stated that the CDP that was approved in 2005 is no longer valid, as significant alterations to the plan have occurred, including but not limited to a lot split and building count changes. An email from the city's law director, P. Robert Brorin, advised Mr. Eric Horvath that a revised CDP would need to be submitted for the Municipal Planning Commission to review and determine whether or not the proposed changes are minor, which it can approve, or significant, which requires approval by the MPC and City Council. An MPC meeting was held January 12, 2023, to review the change to the CDP. After the case was introduced, Mr. Brorin explained that the city had received a packet of information from the Colonial Woods Condominium Association stating that they have been attempting to negotiate with the developer about access to the road. It was established that any new structures would have to be in a new condominium association. At that time, it was not known if any new condominium association documents had been filed. It was further established that any new condominiums would not have access to the amenities of the first condominiums. The case was tabled until March 9th, 2023, to allow for additional information to be submitted for review. A shared cost agreement between the Village of Colonial Woods Condominium Unit Owners Association, Inc., also referred to as Colonial Woods, and EJ Mount Vernon Partners LLC, referred to as developer, was submitted September 21st, 2023. A special meeting was scheduled for October 26th, 2023. Today, the Municipal Planning Commission is charged with reviewing the changes both already made and proposed to be made to the Comprehensive Development Plan that was approved as a binding condition by City Council through Resolution 2005-130 for 32.09 acres, and determine if these changes are minor and can be approved by the MPC, or if the changes significantly alter the approved plan, which requires a plan to be resubmitted to Council for approval. It is the opinion of the zoning staff that there are a number of factors that should cause the original comprehensive development plan for the Village of Colonial Woods to be sunset, and a new comprehensive development plan should be required to be submitted for review and approval, including, but not limited to, the original plan was approved in December of 2005 for 32.09 acres. The presentation to MPC in December 2005 established that the project, encompassing 31 buildings with dwelling units, a swimming pool and clubhouse, with an entertainment center and exercise room, would take between 40 and 50 months to complete. The minutes for the 2005 presentation to MPC also noted a sidewalk would be built from the site to Coshocton Road. A lot split was granted in May 2021 for 14.98 acres. The original plan portrayed one community, named the Village at Colonial Woods. Condominium regulations prevent any additional units from being added to the existing condominium association, the Village of Colonial Woods Condominium Unit Owners Association, Inc., thus requiring another condominium association to be formed. Bylaws for a second condominium association have not been submitted for the MPC to review. The second association will likely not have authorization to use the clubhouse or pool of the original association, thus changing the essential character of the approved plan, which is cited in Code Section 1163.03C as a condition to resubmit to council for approval. Lacey Blankenhorn, Development Services Manager.
Thank you. Any other communications, Mrs. Blankenhorn?
Nothing further.
Mr. Broran, any concerns from a legal standpoint?
The issue before the Municipal Planning Commission is this a minor change or is it a major change? And as Mr. Loesch cited, changing the number of buildings in itself is very likely to be a minor change. But that's not all they're doing here. They are having to create a new legal entity for the new units, which will have differing, they'll receive different services than the original condominium complex. So the question that is before this board is whether or not that is a minor change or a major change for which this board would then decide if the board is a minor, if the board determines it's a minor change, they will then vote yes, to accept the changes and then go forward. If they determine that this is a major change, they will determine that they will then go and vote whether to recommend approval of the plan to council. If this board does vote that it is a major change and then vote to recommend to council to approve, council would then only be able to disapprove with a supermajority. It would take 6 votes of council to disapprove a recommendation from this board one way or the other. So
You said if this were approved as a major change, then council would.
council would then have to make the determination. You would make a recommendation
I wasn't
either
sure. Yeah,
approve
okay.
or not to approve,
I got you there, yeah.
and then,
Can they require additional information?
yeah, oh, well, yeah. There is, of course, the opportunity for this board, as Mrs. Blankenhorn points out, to require additional information before taking. We're not required to do something here today. You can say that we would like to see additional information from the developer prior to going forward, as we did in previously.
Thank you. Anything else from a legal standpoint?
Nope.
Mr. Ball, any engineering concerns that you had?
Well, just to kind of summarize back, we've worked with, on the engineering side, we've worked with both parties on the water system and the sewer, stormwater, and the road. I feel that all of our issues have been kindly resolved. The agreements appear to be mutually acceptable, and this seems like it'll work very well. And then just for generality, we've argued about the sidewalk. We have hired an engineering firm to design the sidewalk for the west side of the road and a bike trail for the east side of the road. Other developers have partnered in that. We also plan to make this 100% TIF project. So
Thank you.
it will happen. The agreement was specific for phase 2. Phase 2 has been sold to Slay Ball, and it will be part of their phase 3. So we have argued about it, but I feel my recommendation is to let that go, and we will get the sidewalk, and we should move on from that conversation.
To your knowledge, has Shade Tree been involved in this discussion at all?
They're not needed to. There is some brush out there, but there's no desirable trees. We can walk them out there if we need to. But
Thank you.
these lots have, as the developer stated, the lots have been prepped. The storm drains are installed. Part of the water system's there. If there's anything, there's autumn olive and brushy type stuff that's not considered desirable.
And you're speaking Specifically of Upper Gilchrist Road, not Abigail Lane.
For the
As far
sidewalks.
as the
The
sidewalk.
site, right, the sidewalk that has been discussed was only Upper Gilchrist, right? I don't believe there's sidewalks inside the development, but they're so low of traffic.
Yeah.
They don't really need sidewalks inside, and again, the road for the entire complex is private. You do not plow snow. The only thing we would do is inspect the storm system, operate the sanitary sewer and the fire hydrants inside. We don't have any ownership of the road. The road will be owned by the HOAs in perpetuity.
Thank you. Well, I appreciate the parties getting together and ironing out the relationship. That means a lot to this commission. I know it means a lot to City Council also. Although I'm not part of City Council, I know that they appreciate that very much. So congratulations on that. I guess the question then before us is whether this constitutes a major change or not. But Mr. Bourne, should we put it on the table before we discuss anything further, or?
I mean, before this board can discuss, we need to have a motion on the floor.
Okay.
And the first issue before the commission is this a minor change to the plan, or is it a major change?
So is there a motion? Either is this a minor change or a major change to this development?
If we make a motion today, are we able to table that motion and seek further information?
I mean, if you wish to continue this to another date, you can do that at any time outside of the motions.
I guess for background, this has had lots of discussions.
Sure.
I think we have a need for housing, and I encourage this group to keep this moving.
Yes, so do I need to make a motion to approve it as a minor change, and a second that we can discuss, and then
Yes.
we vote? Okay.
And
So
you can
I'll-
amend that motion, you can vote it down, vote it up. There's a lot of ways to go.
Yeah.
I'll make a motion to approve as a minor change.
Is there a second?
Second.
Okay,
So
so now
then-
we can talk about it.
And seconded, this is a minor change, so any discussion?
Mr. Lowe, or Mr. Horvath, whoever. So in 2005, the CDP was originally approved. Since then, if it were a child born in 2005, it could vote by now. 31 units was approved on 32 acres. Is that correct?
Was there 30? I thought it was,
Okay.
how many?
I'm looking at
128 altogether.
128. So is that 31 structures?
I think that's probably correct. It's the
Okay.
structures.
Okay, so now that we're getting these definitions correct here, it's down to, we've essentially, with the lot split from 32 acres to, with a lot split, 14.98 acres was split off. I assume that is what was retained with the yellow, is that right?
Yes, this is the Colonial Woods part,
Okay,
and the yellow, well, actually, I think we retained this too, we're just not gonna do anything.
Actually, that's gone.
Is that gone now too? This is,
That went with.
this
so
we have. This
is the
one-
yellow
Yellow.
section is the 14.98
one,
that was
two, three,
retained?
4, 5, 6 structures.
Okay.
And actually, and the ones that are in red, the outline red is part of the property still
Is-
maintained or retained, but it's not going to be built.
Okay.
The lines are
No,
not.
he just,
Yeah, we just heard,
They're not perfect, so let me say, if
Sure.
you want to open the auditor's site, again, it's not.
We
perfect,
don't have
but
to
it's
do all that.
Super close.
My question, if I can, sure, sure.
you'll have, and then we'll have you swear yourself in to offer any
I tried to
testimony.
do this to try to help
Okay.
with the original plan.
If you'll swear
Yeah,
yourself
you need
in, then
to.
that would be great. Then we'll let you talk then.
Here's the sequential ones here.
They're not really changing.
Well, sure. It doesn't matter because I got this here.
My name's Eric Horvath. My address is 20 Waterford Court, Granville, Ohio, 43023. I affirm that my testimony is truthful to the best of my knowledge and ability, so help me God, or under penalty of perjury. What I have here and what I kind of shared with you is I put where the original, this is the whole project that was originally approved. And I put where the original phase 1, phase 2 line was. That's in the deep black mark.
Sure.
And then everything, I guess, to step back, and then I circled up front here what has been completed, so you know what exists right now, and that is the Colonial Woods Association. When we split off and sold off the back side to Slayball, there was a specific conversation about this parcel, and the conversation was, it was made aware to the council that this would be a separate association at that time. Last time I was here, I testimonied, and the minutes do address that, and it says that specifically, that conversation was had. It would be a separate parcel, separate association, when they approved the split to allow that land to be by itself at that point, with the intention that we were creating a new association. When we were building this, we ran into several things. There was a crazy thing called the market tank back in 2008, where everything shut down.
Sure.
And it shut down for 5 years.
If I could stop you.
Absolutely.
Yeah, that way it doesn't turn into something that I didn't intend it to.
Yes, no problem.
So with your, which can be admitted into the record however it needs to be, with your drawing here, the pink shaded area would be
what was sold off.
was what was sold off, and the retained area is in totality, is that 14.98?
That is, I don't have the acreage in front of
So
me
that's, okay.
in any way, shape, or form, so I don't even want to guess.
All right. So really, my question is, it went from 31, this is where my concern with, as Mr. Ball mentioned, there's a significant need for housing, and that has only increased within the last, there has been a significant need for housing, and as you're probably aware of, a little project going on down the road that has created a even greater need for housing here. So what I am seeing is 31 units, which what is listed.
Or buildings.
Buildings go from 31 to 4, which will contain how many units?
These homes here, all the utilities are in, sewer's in, the pads are done, water's there, storm sewers are there.
Right.
And these here will have 32 individual homes.
Home, okay.
Yes,
That answers that question for me. Thank you.
yes,
My concern was best use.
yes.
If we're essentially creating a 15-acre parcel or whatever that acreage is for 4 units or 4 homes,
Understand.
that's a little concerning to
And
me.
all these pads are already there. They were all built with under the original plan when we developed all of phase 1. So all those pads were already built up. They were compacted, and all the soil's there, and not the soil, but all the utilities are there, and the roads are cut, and part of the roads are in as an asphalt for those areas.
Sure. All right.
I'm sorry, could you clarify 4 units or 6 units?
These are 8 buildings, 4 in each building,
Okay.
32 homes.
No, the map here has 6.
This is,
I'm sorry, the map.
Am I reading it incorrectly?
Yes, so
Yes.
Okay.
you have two black lines.
Yes.
So the question is
Okay.
pink shaded.
This pink shaded area was all part of phase 1 still.
Okay.
But that was sold off with the parcel to Schlaball.
That's what I thought.
So
Okay.
the only thing is left is this area here with these 8 buildings.
I count.
I count 6.
1, 2, 3, 6. I'm sorry, 6.
Okay.
My mistake. I'm sorry.
Yeah.
Thank you.
so
For
s-
each.
4 each. So that's 24.
24.
Okay.
Yeah.
24 homes.
Yes.
24 homes, not 32. Got it.
Right.
Yeah.
Mr. Horvath,
Yes.
you and Mr. Lowe met with this commission back in January,
Yes.
and there was a discussion about a separate COA.
Association.
Yeah.
Yes.
You have chosen not to go that direction. Could you explain why?
No, we are having a separate homeowners association. We have no other choice but a separate homeowners association.
Okay, let me rephrase my question. if there is a separate homeowners association, is there then not necessitated a separate plan?
No,
And that, I guess then that's my question. If you were advised back in January, why have you chosen not to accept the commission's recommendation that you have a second plan?
I guess I'm not following the question, and
Okay.
I apologize for that because.
And I apologize for not
Yeah.
phrasing it
If we,
correctly.
just change the paradigm a little bit. The state statute allows you to build condominiums in a community for 14 years, period. Doesn't matter if you finish the project or don't finish the project. If we would have kept all this land, we would be exactly in the same boat we are, except trying to create a new association, because that's what it's done. That's what's been done all the way across central Ohio, is because a lot of the communities could not be finished up because of the market tank and everything shut down. So there are places that have, a lot of places that have the second association in the back because of the state statute only allows 14 years to finish up the first association. And a lot of the strategy is always to build the front and you work your way back. And that's also why that part of the, they have in the condo docs that you have the perpetual easement, non-exclusive easement for the declarant. So that way the land is, you can always use the land. We reaffirmed that easement when we did our shared agreement with the association. So by doing everything too, we reaffirm that easement exists, so we share the costs in that, to be fair to them. And also I was the one that initiated the conversation to say we should have that. I mean, it struggled to get it going in the beginning, but I was the one that initiated, say that's the right thing to do, even though that perpetual easement exists.
So I'm still not clear because you have 2005 and 14 is 2019. This is 2023. So you do have a separate association because you have Gilchrist Meadows and you have Colonial Woods.
There will be a separate association. It's not there yet.
Right.
So, but there will be a completely separate association for those new homes.
So why doesn't Gilchrist Meadows have to submit a condominium association plan to the city?
We're,
Comprehensive
they will.
development plan.
Comprehensive development.
HOA is not the developer or the landowner. So the current landowner is being represented by
Right.
Mr. Horvath.
Okay.
So the landowner has to present it. Colonial Woods, the nice people in the seating area, never submitted anything because as the buildings were created, the developer sells them, and then the city and the county, those become part of the HOA after the owner takes ownership of them. The resident takes ownership of the finished structure. So
The HOA will not come into in existence until they sell the first one. So,
it's not until we can't even create the association legally until the building is substantially complete. That is when we actually end up filing the original documents when the first building is substantially complete. We cannot do that per the statute.
Okay, I think I share what you're getting at here.
I'm not being
It's-
clear, but
because it's-
Mrs. Blanken,
There's no shared use of the pool, there's no shared use of the clubhouse or anything like that, and so there's a different, there are no amenities at this point planned, and so it's going to be a new name, it's going to be a different association, and so why is that not a major change rather than a minor change? Is that
Yes, sir.
accurate?
yes, sir.
Is this,
I
I mean,
kind of-
is this
I kind of
consistent
share
with
that.
what was done with Southgate? I mean, they went through this process a while back.
yeah, they went back to council.
I mean, but
Yeah,
Because-
they had to go all the way, they had to do it all over again, and they went back through council.
the difference with Southgate is the owner did not retain rights to the stormwater pond. So where their plan had approved at 20 units, they had to drop to 19 and build another stormwater pond.
and probably is they did not have any of the utilities already installed. We have the utilities all installed, the roads installed, and the pads already installed per the comprehensive plan.
I think a greater question is whether or not this is going to require significant infrastructure changes, and it sounds like it's just a matter of legal agreements with
Well, it's
who
the
can
question
use a
about,
pool and who can
I don't think
They're not gonna use it.
file a,
We're-
right.
I don't think
And
the
you've already addressed that, correct?
Correct.
So.
I don't know that infrastructure has anything to do with the
No.
zoning.
Well, that's exactly what I'm saying. In those other instances, they had to go back and look at the retention pond, they had to look at sidewalks,
Well-
they had to look at road easements, and that's not the case here.
the
And the
issue
purpose
here
of this
is
board is
whether
to
or
look
not
at
the
a,
creation of a new legal entity with different requirements
right.
is a major change or a minor change.
That-
That's what this comes down to.
That's the point. That's the point for me, and I think that's what you might be saying as well.
And-
That's
and
my
I
concern.
have, during the market tank, I had 3 communities, and they all kind of slowed down. And all the other communities have 2 associations. They have the second association, and this was never an issue with the other municipalities.
And isn't the, I mean, with all due respect, I know it's a little different, but people that are coming to purchase in this community will know they don't have a clubhouse. So, I mean, it's not like it's gonna be a shock to them about what amenities are available.
Hey, they can swim in a retention pond, right?
I hope not.
That was a joke.
If the health
All right.
department approves it.
Yeah, there you go. Mr. Broren, roll elevator pitch on this. How does one create a legal entity such as this?
They have to file the various documents with the county recorder.
We only take, as your former county recorder, it only takes 1 day to record that. So
But
there you
we
go.
can't file it.
Until we approve.
start a building and substantially complete.
I heard you.
Yeah.
So there you go.
Round and round we go.
All right.
And-
Well,
and
I'm
we-
satisfied.
And on the documents that we have, that we put together, specifically in the document, it references the shared cost agreement that we have with the existing, so it's all documented
Yep.
as part of it.
Okay.
Anything else for us, or?
I don't think so at this particular point in time. So I'm still just, there seems to be a significant number of changes that are going along. We need housing, we know that. And condos are a great fit. They're a great fit for this community. And at the same time, there are a number of issues that our development services manager brought up that, to no one's particular fault, a lot of things have just happened since 2005, and I'm pretty confident council would want to see something like this. That's my opinion. What? But correct me if I.
Well, I hear what you're saying, and I
Go
guess
ahead.
do you want to say that to Rob before?
Well, the legal standard is not whether council wants to see it or not.
Right,
The
that's
legal
true.
standard
Yeah, I
is.
get that. Thank you for that.
Not
Thank you for
that-
that, yeah.
I mean, I don't feel like we're taking a shortcut here. I mean, I think in the end, it's going to end up the same place, in my opinion. If we make them take the long road, we're going to end up the exact same place we are. I mean, I understand the fact they're creating a legal entity. It's borderline. I understand that we're making a major change, but in the end, I think the people of the community and the people of Mount Vernon really aren't going to be impacted in any negative way. I don't see any negative side to go ahead and approving this because I just don't, other than the legal entity, it's really not impacting the actual citizens in the community.
What is the risk of saying yes today?
Yeah.
Well, I hear that, but I also hear that it only takes 1 day.
To record.
To record
record.
it. But they can't do that until they go through. I just, I don't know.
But I'm just a volunteer, and I feel like I should yield to the experience of our development services man. So that's why I am not in favor of saying this is a minor change, but I'm in favor of saying it's a major change. That's my opinion.
I agree with you, Mr. Hawkins. It's a major change, but what ultimately is what is the difference going to be?
The difference would be that they would have to submit a comprehensive development plan showing what they're intending to do with the remaining property. That would show all of the things outlined in 116302, the development standards. If you look at the original legislation, it specifically named Colonial Woods, and now this is not Colonial Woods.
Understood. Yeah.
And for me, if Colonial Woods clearly had, when we were here in January, they were obviously against it. I mean, it was, the fact that they're gotten this far to me is quite amazing. And I guess for me, the fact that they don't view it, and I guess I shouldn't, they're not, you weren't speaking for the entire group, but no one spoke out against it, to me shows they're not viewing it as a major change. And I don't know. That's just my opinion. Since we have a motion and a second, once the conversation's done, we need a vote.
Well, the vote is the call of the chair. I mean, once
Yeah,
once the chair
I'm
determines
just still
that-
going, I do see your point.
I'm not trying to
Are we
rush
gonna
out
end-
to
No,
ask.
I'm- I do see your point. We
Yeah, I'm not trying-
we'll end up into the same place, but the
almost dinner
process of
time.
this, I think is part of the thing that I think what Mr. Swallow and I are sharing in terms of, okay, well, there are a lot of things that are changing here,
Sure.
and, you know, it
And there's a
Now-
process for that.
yeah.
Yeah.
That's where I stand on that. Anyway, anybody else before we call the vote?
May I ask a question?
Sure.
Have you reviewed the development standards for a PND and what the comprehensive development plan requires?
I haven't today,
Not
but
this morning.
would you please
Well, one of them that really jumps out at me under 116302C, the site development requirements in a planned neighborhood district, letter B is location, size, and type of non-residential uses such as open space, parks, playgrounds, community facilities, and schools to be located in the land to be developed. And at this point, there is nothing. There is no plan shown for that because it all went with the original association.
That's not inaccurate. Yeah.
And while you're addressing that, can you address whether or not this current layout that you intend to develop is similar at all to the intended development?
It is, first of all, the green space is kind of broken up and between the communities, and a lot of the green space over by the retention pond is retained and owned by these lots here. It's part of their ownership. It's not all part of the original. So if we did a calculation, probably there's a higher percent associated with the property that's left than there is on a per home with the ones here. And as I look at this, it was all developed. This is no different than if you build single-family homes and somebody develops all the lots. Utilities are in, streets are in, the pads are in. You build a house today, you build a house tomorrow. All we're doing is building the house. We're building the houses for that on the pads that were already put there, the utilities that were already put there, that were installed per the plan. The pad, nothing changes from this plan. The layout doesn't change. The floor plans do not change. They're all the same.
And that's what was in the original plan?
That was what's on the original plan. Correct.
Why wouldn't you still call it Colonial Woods Phase 2?
Well, this was because when we were talking with the Colonial Woods, they would like to have a separation so there's no confusion. That is why. Originally, we came in with Colonial Woods Phase 2. But they asked that, so to work with them, their wishes, we created a different name so there wouldn't be any confusion.
So the items that Mrs. Blankenhorn just recited from our PND requirements, in your opinion, have already been addressed? Is that what you're saying?
I'm not sure they are an issue from what I'm seeing because everything's been installed. All we're doing is building the homes on the lots that already been built. I mean, so that's what we're doing. We're building homes on the lots that have already been built and developed. That's all. That's what we're doing.
I will say that the road is partially there. There are curbs for a little while, not all 6
But all, they're
Units.
cut in, but
Yeah.
the sewer is
Yeah.
there, the
Yeah.
pads are built
Yeah.
for the homes. I can't change the pads because they gotta fit on those pads, or I can't build there.
Yeah.
Do you have you provided us copies of the new deed restrictions that will go on these documents?
He has declarations.
No,
correct?
that wasn't the question. Question was, have you provided us copies of the deed restrictions that will go with the new properties?
Are you talking to me, or are you talking to?
Either to you or to Mr.
Okay,
Lowe.
because you were looking that way, so I was
sorry.
just, yes.
Deed restrictions being like the agreements between the use of the road and the lights.
Yeah, it's whatever they're agreeing to. It's a requirement that they provide that as part of their submission.
Well, there is a recorded document that I believe you were provided with, even according to their Colonial Woods' email. That's all, that has been filed, that
No, but
lays out
that's
what
not
those
for,
are.
that's not for the new pieces of property that you're wanting to sell.
Well.
Yes, it
we're-
is. It could, it
We're not
is,
selling it.
it controls, I guess, what they have to do. I don't know what deed restrictions you think are supposed to be there that are beyond the
The
declaration.
agreement that you have brokered between the HOA and the developer, do we have a copy of that agreement?
Yeah, we've seen that.
Yes.
Okay. Is that what you're asking for, Rob?
And it talks about, it does to some extent blend over on the current property, because it talks about things on the current property, or the new, this part we're talking about, the responsibility of Gilcrest Meadows to pay for those things.
And if you're talking about the structures and the types, and we're not changing one thing from when we originally did the plan on the type of homes and the structures and what's living there, what we originally approved. Which covers all the existing land in that project and in this additional 6 buildings.
You have withheld from filing those declarations because we have not.
Well, we can't.
We can't
Well,
file it until.
We're not saying that we want to see them filed.
I understand
They are
that,
required to
but
file with
deed-
us
Okay.
I have no problem.
those documents,
I have no problem sharing those with
they
you.
but you
exist.
haven't done that yet.
Well, you haven't asked for it
Well,
either, so.
it's part of the submission requirement.
Well, no, it's,
I think we're
if it's a
talking around
major
each other.
change, it's part of the submission requirement. We don't think it is, but I think
call the question.
I know that I've communicated with you multiple times. Tell me if there's something else you want, and I haven't heard you wanted these, but we have them, if you want them.
Well, actually, we did say in,
I think I saw the emails too, you asked them.
Okay.
Yeah.
I did ask you, but if you
Well-
want to see them,
well, we said in
Here they are.
December.
You're more than happy to have a copy if you like.
Anything else before we call the question here? Mrs. Blankenhorn?
Mayor Starr.
No.
Sorry, my thing is messed up. Mr. Sawyers,
Yes.
Mrs. Ellsworth,
Yes.
Mr. Hawkins,
Yes.
Mr. Swallow.
No.
We have a 3-2 vote that it is a minor change.
It's a minor change, and so it will move forward.
So the
Any-
question is, so the next is, yeah, the next thing is the council, the municipal planning will decide, is this to accept the minor changes that they're requesting?
So motion to approve the minor changes as presented?
Yes.
Second.
Been moved and seconded for the acceptance of this as a minor change. Any discussion?
You should say, the motion was to accept the plan.
Yes.
Plan,
As presented. Did I not say that correctly?
You said minor change.
well,
Okay.
I think you,
yeah.
As presented.
Mm-hmm.
Any discussion?
So we're taking a vote to approve the plan as presented.
Yes.
would we suggest a caveat that someone is given authority to review the HOA declaration?
I would feel comfortable with that.
Just as an advice that that document needs to be, but it doesn't have to be reviewed, right? Is that correct? When would we review this document? Would that be done administratively in a minor change? Because it's not required now to be submitted, is that correct?
It's part of the plat approval process
Okay.
Yeah.
that is supposed to go before municipal planning.
So it would be in the next action, not today.
I would also require, if we have the authority to do that, that agreement should be filed as well with the recorder's office.
Well,
We need to let my motion die then?
No,
Your motion's still valid.
Yeah. it's-
no, is that what they're discussing here is amendments to the motion for the approval. And
Well, first question, did anybody second it? I'm screwing this up.
Yeah.
Yes.
I
Yes.
second.
I'm not being a good
Who did?
advisor here.
Yeah.
Tanner did?
Yeah, I did.
At least you didn't have that written down.
Okay, so
Okay, are we,
we're going from here. We are we are looking at taking a look at the new homeowners association.
And so is someone amending the motion to approve the documents as presented to require them to submit to Development Services for administrative review of the HOA covenants and declarations?
let me ask you a question first. You mentioned plat approval, which is this board's, we are approving the plan. Are we approving the plan and the plat?
No, just.
Because we don't have a copy of the plat.
No,
That's-
we're approving today the alteration to the comprehensive development plan.
So then, in the minor change, should the HOA documents and the plat be packaged together?
Yeah,
So that's not today.
yeah.
The comprehensive development plan is supposed to have the plat with the deed restrictions. We do not have that.
Then I would amend our motion to include what is necessary under the statute, which apparently is available to us, correct?
You can have those right now.
Yeah.
Well,
I don't have, the plat is the drawing that you still have. I guess
Nothing changes on it.
nothing changes on that. If you want to see these, I certainly, we have two copies. If you want to see
Well,
them. There's a couple of copies, who wants them.
please have them over there, yeah.
Two copies of both those.
all right.
Again, I know you had said you want them to be filed, and they certainly will be, but we can't until.
Yeah.
Sure.
Yeah.
Yeah.
So, we have amended to,
We need a second on that.
we need a second yet on this to,
Second on the
on the
amendment?
amendment.
Yeah, I will second the amendment.
Okay, it's moved to second to amend this to, would you please recite the amendment?
I don't know, you're gonna have to tell me.
Okay, you're to provide that this is a minor change with the approval of those two documents that you have before you. They're the deed restrictions and the
Declarations,
declarations.
Who are you delegating the approval authority to?
administrative.
It's
Administrative.
administrative approval.
There you go.
That's the amendment for administrative approval of those.
Okay.
So you're amending Mr. Hawkins' motion to approve the plan as presented to, what's the amendment for?
Make
To
sure-
include the declarations, what you just received,
To
the two
include-
documents that you just received.
An administrative. So the review, the approval becomes conditional on the approval of those two documents by the administration.
On the plat.
Not the plat. Right? We already have the plat, and the plat doesn't change.
That's my understanding.
Just the declarations and the deed restrictions.
Okay, so who seconded the amendment?
I'll second the amendment.
Tanner did. Any other discussion? Then let's call for the vote, please.
This is on the amendment,
This is on the amendment.
to amend the
Yeah.
motion. Mayor Starr?
Yes.
Mr. Sawyers?
Yes.
Mrs. Ellsworth?
Yes.
Mr. Hawkins?
Yes.
And Mr. Swallow?
Yes.
is approved. So we will have the,
No,
Right.
now you need to call the main question as amended.
okay, thank you. You guys don't make it easy, I'll tell you that. Man. Now,
So many
is there a
votes.
question to,
I move to accept
Thank
the
you very
motion
much.
as amended.
is there a second?
We don't,
No, we just need to
No, we
vote
got
on
that.
it, right? We've already done that.
Yeah.
That was my initial.
Don't need another motion.
we're now voting on the amended
Yeah.
original motion of Mr.
Oh,
Hawkins.
then call the thing.
My bill, we'll call it my bill.
Yeah.
Hawkins bill.
Hawkins.
Hawkins bill.
Mayor Starr,
Yes.
Mr. Sawyers.
Yes.
Mrs. Ellsworth.
Yes.
Mr. Hawkins.
Yes.
Mr. Swallow.
Yes.
Okay. I think we're good.
Lesson in Robert's rules there.
All right. Motion as amended is approved.
Yeah.
Okay. Anything else on that? We've got one other item that we need to talk about here yet, so. That is, we do not have to make any determinations tonight. That's fine. We can just give this a reading. Well, if you leave, we don't. Well, wait. No, yeah, there's four.
Yeah.
That's right. All right. Yeah, you can. We can give this a reading if you want, but commission members, one of the things that this administration wanted to do was to have for each commission and board to have their own independent bylaws, not only for, well, it's good planning, but it's also, it will help us out with recruiting and also with the clarification of roles and so forth. And so, like I said, we don't, if you're all comfortable, we can give this a reading, let it sit on the soak cycle for a little while and rule on this at the next Municipal Planning Commission, if you like, so.
Mr. Mayor, I move that we give this a first reading.
Is there a second?
Second.
Okay, we'll give it a first reading. Thank you all. Anything else?
So I need it to be tabled.
Can we table this then?
Yeah, let's
Just table it.
Friendly restatement.
Yeah, all right.
Let's restate that.
However you need it.
To be tabled to the November Municipal Planning Commission.
And who made that motion?
Mr. Salyers did.
And seconded by Mrs. Ellsworth.
And we're tabling it till when?
The next
So December.
December. Yeah, the December.
We're not meeting in
December, we're not
November.
meeting in November, that's right. Thank you.
December meeting.
Somebody's going on vacation.
Oh, I get
Is
it.
there any other business before this commission?
Do I need to take a vote on that?
Yes.
Mayor Starr,
Yes?
Mr. Sawyers,
Yes.
Mrs. Ellsworth.
Yes.
Mr. Hawkins departed, so Mr. Swallow.
Yes.
It is tabled.
Motion to adjourn.
Second.
Been moved and seconded. All those in favor say aye.
Aye.
We are adjourned. Thank you all. Thank you for your patience. Yeah, I do too. Oh, sorry.
We gotta coordinate that better.
There you go. Uh-huh.
Thank you.
Let's work this good.